May request, if any, from item number 1 to 15.
Please, I beg to mention item number 10 for an adjournment on the ground of bereavement in the family of the conducting counsel, Mr. S.P. Sharma Lodge.
Which item are you mentioning?
Item number 10, Lodge.
Item number 10 is with item number 9.
8 and 9.
8
Yeah,
and
only
9.
for item number 10.
Have you informed the council for item number 8 and 9?
No, Lodge.
Then wait for your turn. We'll see. Mention them.
Much of.
Item number 16 to 28, 29.
Item number 17, Lodge.
17.
17, Lodge. 17.
What do you want?
Maybe day after tomorrow, Lodge.
This is you are for the petitioner,
I'm for the petitioner.
Union of India.
Yes, Lodge.
All right, as prayed for by the. Have you informed the other side? Have you informed the other side?
No, Lodge.
None appears.
None appeared.
No notice has been issued.
No notification.
As prayed for on behalf of the petitioner. Let this matter come up for consideration after 4 weeks. This is right.
29 May.
70.
Dismissals are compulsory. Yes.
May it please your lordships. Lordships, we had circulated an adjournment request with regards to item number 23, your lordship.
All right. All adjournments
23, 22 also.
22, nobody else.
No, but we just wait together.
So 22. Have you informed the council for 22?
Lordship.
All the 22 and 23.
12 June. 12 June.
Lordship, however, we could not get a hold of the council for item number 22, your lordship. Therefore, they could not be informed, your lordship. And it was tagged. There is no order as to why it was tagged.
Anyway, you inform now.
Lordship, will.
Post-decisional information also would do. Please go and inform.
Lordship, much of it.
All right. And if he comes and says that I have not been informed, then I shall withdraw this. Then I'll hear you tomorrow.
Lordship.
Any other request?
I beg to mention for listing, urgent listing. But tomorrow, can I move it?
What is the
My
matter?
lord, that matter already decided by your lordship. RCC training, my lord. Just few candidates left. They also want to.
You will come, keep on coming. That's
just want
an
to-
order in REM, I suppose.
Because one part of
That's an order in REM. If you don't advise your client like that unnecessarily, you'll be flooding this court with petitions. We have been careful in deciding the issue and not with respect to particular persons.
your lordship is.
Would you be required? That'll govern. I don't think you should. Today also there are 2-3 matters in this
There's also
supplement.
two matters are listed.
I think that covers your case without an
I
order.
can move it today itself, my lord, if your lordship desires, my lord. With the other cases, my lord.
You will not have it drafted today.
Tomorrow, my lord. 30th is the last day, my lord. 30th of this
It's
month.
true, but then you are covered by that judgment. You don't need an order, do you?
One direction is there, man, to allow the petitioners to participate. Only that part, my lord. Just that limited part, my lord.
Haven't we decided the issue before that?
Yes, sir. Your lordship has decided.
Then-
your lordship has helped. Public, deeply, public.
Daily list for this item 1.
So, yeah,
So this is my inadvertent mistake, my lord. I can
22 power.
inadvertent, my lord, here I, if honorable court permit, may I submit one thing, my lord?
No, but
Only one thing.
who is in charge of the registry when we say that if the requisites are not filed, then the petition shall be dismissed without further reference to bench. If these are peremptory orders, why does it come before this court? इसका मतलब तो यही होता है. These are peremptory orders.
Yes, ma'am.
We
I
can't.
will- Yes, ma'am.
We possibly cannot.
Yes,
We'll have to recall our order dated 20th of February.
ma'am, may I submit one thing, my lord? This issue has been,
You file afresh.
yes, ma'am.
File afresh. We are dismissing it.
I cannot say because lordship's order is there, ma'am. My lord, I may submit one thing. This issue has been resolved by order dated 19/11/2020 by this honorable court also, my lord. Same issue, my lord.
No steps have been taken up till now by the petitioners for issuance of notice to the sole respondent. by order dated 20th of February 2026, this court had passed a peremptory order, on 20th of February 2026, this court had passed a peremptory order that if steps are not taken within the time prescribed by this court for issuance, steps are not taken for issuance of notice within the time prescribed by this court, the petition shall be dismissed without further reference to the bench. However, notwithstanding the clear order on 20th of February 2026, the matter has been placed before us under the heading orders. On special request made by MSA Guyam, London Central Government Council, we permit the petitioners to file requisites for issuance of notice to the respondent within 1 week positively, whereafter notices shall be issued by both modes to the respondent. Failing which, the petition shall be dismissed without further reference to bench.
Master bless me.
Date
Master
written
bless.
will not, but don't do it.
Yes, madam, that is nice. I apologize for that.
Give the date sometimes in July. July.
Item 224.
Let all these matters be listed for admission on. We keep it next week. The eviction has already been done.
No, my lord.
Or threatened eviction.
So, may I just explain, Milord? There was some dispute with regard to boundary of the wildlife sanctuary. Survey of India entrusted with the responsibility by this court to do the needful, Milord. It was done, and government has, Milord, accepted the boundary demarcated by the Survey of India. Now they'll have to take further steps because in the meantime, the boundary has been
Let it
increased.
come for admission, we'll decide.
Fine, Milord, fine.
Let all these matters come up for admission on. Give it sometimes in May.
Fine. Highly obliged.
28th May 20. Item 5.
Steps on 7 and 11.
7 and 10.
May it please your lordship, this is for steps on reference number 7 and 10. My prayer is that their name may be deleted.
At 7 and 10.
Where have you made that application? Where have you made that application for a deletion of the names from the array of parties?
My lord, I have not yet filed.
Why you must file it, no? Only because you have not been able to file requisites, you want to delete. There is a process for doing it. File a 1-page affidavit that you want to delete the names of the respondent. Yeah, as straight for on behalf of the president. Yeah. But somebody that's best. Anyway, you file that application.
My lord.
Mr. So-and-so learned advocate for the petitioner seeks a week's time to file an application seeking deletion of the names of respondent number 7 and 10 from the array of parties. Let that application be filed and this application will be listed on after a day under the same heading.
22-5.
Back report.
Item 6.
For respondent delete.
Lordship, office
Awaiting
note.
the appearance of respondent number, sole respondent, the matter is adjourned to. Thanks, Vivek.
June. 15/6. Item 7.
Your Honor, please. Your Honor, this is the content petition which I filed, wherein my lords, a willful disobedience of the order has been taken place. My lords, a writ was filed by me, wherein my lords, Your Honor has passed an order dated 10th of December 2025, wherein my lords, directions were given that possession of this property in question will be handed over who are.
Why is it for order? Ajay, it's a contempt case.
It's a contempt, Your Honor. It's a contempt. My lords, allow me to read the relevant portions of the writ petition, wherein my lords has passed an observation, wherein my lords, the opposite learned counsel stated that Ms. Sharma, my lord, this is,
Just give us a minute.
yes, Your Honor.
Contempt. No. No case for contempt. Sorry,
May I submit, Your Honor?
no case for contempt is made up.
My lords,
You have a
kindly,
different forum to agitate.
my
not
lords, kindly appreciate, just hear me for 1 minute. My lords, since this is an observation which was passed by this honorable court. Now, my lords, whereafter the direction was passed that within 3 working weeks, if all the documents and everything will be deposited before the concerned respondent, so the compliance will be taken place. Your Honor, prior to that, my lords, there's a respectful submission, section 14 of SAFASI Act, which states that
We are aware of that.
my lords, it's a mandatory, my lords,
What,
it's a mandate.
Sharma, what happened?
Lordship, may kindly take up my counter affidavit.
What have you said?
Well, the area of the land, the boundaries of the land do not match. And well, the satisfaction, although
lords.
he has no, as my learned
My lords,
friend has submitted, that it is ministerial on the part of the deputy commissioner. His satisfaction.
You also, as an officer, under mandate, under section 14, you should see that if it is a clerical mistake, don't go by it.
It
My
is
Have it
not,
corrected.
my lords,
it
But you
is
can't
not.
claim it as a matter of right. You correct it and then perhaps.
my lords, there's a
Well,
request, please. My lords, there's a small rebuttal to
Let
that.
it finish.
Now, my lords, what has happened? They are saying that the areas are not matching, this is not matching. Now, my lord, once this matter was being heard before the concerned DRT, Your Honor, the concerned DRT has given an observation very vehemently and categorically, wherein my lords, the learned DRT has stated that when the gentleman, the borrower, he has taken the loan, it was the borrower who has annexed this property documents which were registered. It was at that time, everything was taken by, was produced by him in hand and seal. That time, my lord, there was no objection that, my lords, allow me to read the relevant paras. Now, my lord.
Counsel, I don't think this should be your argument now. Your argument should be that if there is any mismatch, we'll check it up and then we'll come back to the court again. That's the way you deal with the matter. You
Well,
think we are going to pass any order in this when there is an objection that the property description does not match?
No, my lord.
Therefore, seek leave, file it, and if they don't do it, then come back.
My lords, kindly appreciate, my lords, kindly appreciate. Just 1 more minute and then I'll bow down to this honorable court, my lords. My lords, the only respectful submission is that now since the DRT, they have not able to prove their matter.
Mr. Counsel, you run the risk of then our observation in the case that because it doesn't match, therefore no case of contempt is made out. You take time, do it then, and then come back to us again.
My lords, representation has been given.
If you don't follow
I'll do
our
that, I'll do that.
advisory, we can't make you understand.
I'll do that, Your Honor, I'll do that.
Why can't you understand what the court is trying to tell you?
Please.
For your benefit.
My apologies, Your Honor, for that.
As prayed for on behalf of the petitioner, let this matter come up for consideration. We are giving you 4
Please,
weeks.
please,
You
please.
do in the meanwhile, in the meantime, this remains pending.
Please,
Otherwise, we'll dismiss it saying that you have not done it.
sorry, Your Honor, my.
See, youth is all right. Young, the afflatus of youth, we understand. But when the court is repeatedly telling you for your advantage,
Tender my,
otherwise Ms. Sharma would be absolutely happy in your argument.
tender my apologies.
All right.
Please, grateful, Your Honor.
12 June.
The date is not.
Item 8 to 10.
12.
Yes,
My matter may be hard, my lord, first.
that's all right. Adjournment has been sought in one of the matters.
Oh.
Item number 9. Check it.
He was accountant, my lord. He's senior to the private respondent, but he was not promoted.
We have decided this issue, no? Wait. Yeah, Mr. Das, where is Mr. Das?
Yes, my lord.
What instruction?
The instruction is that, my lord, my humble submission is that there is no perversity.
No,
Sorry,
come to order.
regarding the rule.
29/10/2025.
Yes, that instruction I have.
We have
I'm sorry.
ratified the decision of the High Court. We set aside the decision of the learned single judge. But so far as the observations are concerned, we said that no rules should be made. Because unless there are specific rules, then the Shetty Commission operates. Correct. It's the same case with respect to.
No, my lord. That is item number 15, my lord.
No, therefore, in that case only, if there are no rules, it's a Shetty Commission. If, in view of Shetty Commission's report, which was the basis for the learned single judge to have upturned the entire decision, that even grade 3 and grade 2.
No, my lord. That is item 15.
So that's item number.
It is listed, my lord. It is item 15.
Oh, so this is which matter?
This is a matter, my lord, wherein there was an equivalent sought for the post of UDA and accountant. My lord, there is no cadre of accountant in the rules, ministerial service rules. And situated thus, the Honorable Single Judge has held that since it's an ex-cadre post, so no equivalence can be made. And accordingly, the promotion to the post of head assistant has to be made from the feeder post of UDA, my lord.
We agree with this.
So that was the.
Correct. So the determinative factor in all these in service jurisprudence would be the creation cadre structure. Because of pay parity, one can't say that the same post
Yes.
is there. That is the law.
That is the law.
In earlier occasion,
Give us the instructions. Take the instruction. What is being done with respect to amendment in the rules?
My lord, latest instruction I don't have, but the last instruction is that, my lord, it has been finalized by the High Court in the administrative side by the committee, and it has been forwarded to the government. And after the formation of the new government, my lord, I think it will be finalized. The notified.
We adjourn it for about 4 weeks, and then we see what happens. But
In
otherwise,
the meantime, things.
it is not going to make any change so far as the structure is concerned, so far as the judgment is concerned. No.
The petitioner has only 1.5 years service mileage in his study. So my humble request, my lord, the matter may be hard and judicial order may be passed, my lord, because the earlier occasion, same establishment, accountant was promoted to the head assistant, my lord. He has been retired. Your lordship kindly see the page 55 of my petition. The order, the earlier accountant was promoted.
Mr. Das,
Yes.
tell him he's by your side, he'll be more audible to it. Tell him that this way he would be spoiling the case of his client. Now, with the change of the rules, we are going to affirm this judgment. And therefore, we have asked only for, activating the High Court and the government in conjunction for making all the rules. And creation of cadre is not judicial function.
No.
So therefore, make him understand that he should not insist for disposal of this case today, because he can spoil his case and not the others. If he doesn't understand, we can't help him.
And one adjournment is so by
After implementation rule of High Court, that we could take it another. So 4 weeks is too long, no? Petition will be retired by this.
Anyway,
Wait
for,
My lord, they will be fixed after 2 weeks because the petitioner has short period of service, my lord.
as prayed for, we are giving 4 weeks.
After 2 weeks, maybe.
As prayed for, one of the, who had made prayer for adjournment? Item number 10. On whose behalf do you seek? As prayed for on behalf of the appellant in WA number 67 of 2026, let this appeal be listed on, after 4 weeks, let appeals WA number 349 and 349 of 2025 and 336 of 2025 be also listed along with the aforementioned appeal on the same date. Chile next.
12 June.
Your lordship has,
Alia.
Item 11 and 12.
your lordship has own judgment. So without rule, the promotion was made by the it's Senugapa case, my lord. Your lordship has appeal. Without rule, get.
Come on, day, Mr. Sharma, we will hear you.
Much obliged.
I'm speaking time being for the, also for the time being, the council is held up in court number 10. First.
His service would have ended, the contract would have ended in 2025.
Lordship,
Now, why do you want to challenge it? What, we will not permit you to recover.
not recovered. We have not paid that part.
You have not
We
paid
have
them.
paid.
Let him have his time.
Lordship.
I think you must pay now that he has retired. Had it been continuing one, you would have said something. Otherwise, we go by the single judge's judgment.
1%, probably the first one is still continuing. Second one,
There are many other places where this kind of an order has been challenged. Are you aware of it?
Lordship, but those were not in favor of.
But then he would be entitled to argue that his remuneration would be in terms of the contract. And your master circular also says that it cannot be reduced during that lifetime. Maybe that in the first instance, you calculated it wrong. You did not take care of that circular which says that it has to
Yes.
be in a particular slab. It has to be 1/3 of the pension and all that. But then once you have entered into contract, can you reduce it?
After that,
And he has retired, you must pay. Anyway, why do you want time?
Will be coming, pass over for the
As
time being.
prayed for on behalf of the respondent and agreed to by the learned council for appearing for Union of India. Let this matter come up for consideration next week. Get ready in the matter. Otherwise, if there are other high courts which have done this,
Right.
or in the state other orders have been passed, or payments have not been made, we will consider. Otherwise, we think we should go by this.
but
Single judges.
but for whichever advertisement now we are giving lordship, that clause has already been there in.
Is he questioning that? No, then,
But-
no, it is a matter of making payment to a person who was under a contract
Lordship.
and his contract is over. So you
Some-
must pay.
That contract was for 1 year. They extended after the letter
Whatever
also.
it is, the contract was extended, no. So therefore, if the contract would have been continuing, you would have taken some pains of getting into the matter whether it was properly done or not. Now that he is retired, he is sitting back at home now. Give him that. Anyway, find out on the next date. If there are other high courts which say that no, this can't be made, recovery has to be done. You have not paid. You were wise enough not to pay. Is there a direction for payment in that
No.
single judge's order?
Single judge's order, yes.
And you'll have to comply with that. Let him come.
Lordship.
8 May. Item 13.
Yes, Mr. Boyan.
May I please, your lordship? My lord, I seek apology, my lord. I could not wear the proper attire, my lord, to the duties of this, my lord.
The ticket.
My lord,
It takes time to procure a different kind of a gown.
my lord.
But then, congratulations otherwise.
Please, my lord.
Doesn't matter. You want to argue today?
My lord, my lord, actually on the last occasion, my lord.
I think the nature of gown does not make any impact so far as the court is concerned.
No, no, my lord.
Unless you think otherwise, we'll give you time. Go and have a senior gown.
My lord, this is a matter, my lord, wherein the petitioner had been terminated from his service by a committee, my lord, which is actually was.
He asked you to
No, my lord,
show us the letter of affiliation.
My lord, the affiliation letter was not there, my lord, but the provision which has been adopted by the committee, my lord, is, my lord, may be pleased to find is at page 60, when the decision was taken, my lord.
Page 60.
Page 60, my lord, the last paragraph of annexure 2, my lord.
0.
The society running the administration of the academics of the college should mandatorily be registered. So, my lord, a society of these type categories of colleges are required to be, my lord, constituted or registered. Now, my lord, this flows from a, my lord, guideline issued by the University Grants Commission, my lord, which we have made as a part of record, my lord, in the affidavit, my lord. So therefore, my lord, on the last occasion, my lordship wanted to know from the state that what was the exact position, my lord, regarding this my lord, affiliation, my lord, from the higher education department, my lord.
Mr. Das was appearing on the last occasion.
Look, I need some time to bring the instruction. Madam.
What are you hiding behind MS Sharma? You should have come in the first instance, no? You need to respond to this. Now, we would like to know the source of power for the DC to suspend this committee which had been working.
No.
That is his only concern. Otherwise, it's okay. Karimganj College, one of the old colleges imparting education in law.
No.
But then we need to know the local, the source of power for the district commissioner to suspend a meeting and then constitute another committee, which would be a sponsor. You see, the steering committee is selected by the sponsoring committee.
Madam.
Now here, who becomes the sponsor now? The state. Are you paying the salary of the employees? Now then, in what capacity the DC would get the power? That is his argument.
Madam.
A reasonable argument, but I think you have to tell us what is happening so far as these private law colleges are concerned.
I'll get an instruction.
When will you take instruction?
The
The person has been suspended and he has been removed from service.
within 2 weeks, Madam, I will get.
Again, Mr. S. Das, no? Yes, Mr. S. Das, Planning Council Higher Education Department, seek some time to respond to this petition and file requisite affidavit in case the same is required. Let such an affidavit be filed positively by the next stage, re-notify 4 weeks.
Deeply obliged.
76. Item 14.
Nobody appears on behalf of the appellant for the reason of the name of the lawyer not being reflected in the cause list. Perforce, we have to adjourn this matter. We do so with a direction to the registry that the name of the counsel for the respondent shall be printed in the cause list henceforth. We notify this matter on next week.
Well, I have a prayer, madam. In the recapital manner, they have not annexed any annexures, any
Let the
affidavit.
lawyer come.
11 May. Item 15.
had decided this matter, no?
Decided.
The facts have overlapped in 2-3 cases so far as I am concerned.
Yes, my lord. And it is up to the level of Supreme Court, it has been final.
Now, what is he doing now?
Your lordship, my case is in a limited campus, my lord. Your lordship will turn to page 62.
Yes.
Eligibility criteria. 1, for promotion to stenographer, 1. Completion of 5 years of service as stenographer grade 2 or grade 3. Now, my lord, my case is this. Respondent number 3, 4, 5, and 6 did not have that qualification, eligibility criteria. They have not completed 5 years, either in respondent grade 3 or grade 2.
And who are you?
That is the case. My lord, I am grade 3. I am grade
So
3.
if these people are removed, do you get in?
Yes, my lord. Only thing is this, my lord, my mark less by 0.09 with last number 1. If this 3, my lord, if this 4 is out, automatically I will get. Even 3 posts will remain.
He is not questioning the principle on which we have decided. He is saying something else. We would have turned him down if removal of 3, 4, 5, and 6 or any adverse order in there with them would get him in. Correct.
And thing is this, my lord, learned single judge.
No, but did he pass the speed test?
Yes, my lord.
All, my lord, it's a merit
0.09
list, my
or
lord.
less.
So in merit position, she was in a lesser, with lesser marks.
But then if this is a fact, then he will, there is 4 respondents will have to be noticed. That time we decided it for the reason the learned single just said that no, in the this is now Shetty Commission's report.
No, my lord, her case is at page 97 before the learned single judge that the combined service cannot be taken up, or 2 or 3 rule says his case, her case before the learned single judge was that, my lord, combined service cannot be taken up.
No, that principle he will have to say. He says
Page-
including 2 or 3. Because these were, if I remember vaguely, in
Yes.
fact, those days,
Yes.
when it was argued, 3, 4, 5, and 6, they were initially in grade 3, they resigned, they joined grade 2 afresh. Is that correct?
Yes.
So therefore, there was a break. And therefore, 5 years, whether this could be taken into account. So, or does not say and. So therefore, they have to be noticed.
If the facts that has been recorded by the learned single judge at para 97, this fact was perhaps this was not argued before the learned single judge, my lord. Page 7, para 7, page 97.
So go to 3, 4, 5, and 6.
Fine, my lord.
Regarding the point that I did not argue, thing is this, my lord, learned single judge said that category 3 candidates will not come in the zone of consideration. That is why my case was not considered at all. Is not considered at all.
We have heard Sri M.A. Sheikh, learned advocate for the appellant. The objection raised in the present appeal is with respect to response number 3, 4, 5, and 6, who did not have the requisite qualification for being considered for grade 1 post of stenographer. He further submits that if they, bracket response number 3 to 6, are ousted, the appellant gets into the merit zone. Let notice the issue to response number 3 to 6 on steps being taken by the appellant within a period of 6 weeks. Within a period of 4 weeks, both modes returnable on August 1st week. Mr. Das, learned counsel for the High Court, shall also respond to this petition. Now, would you remain counsel for the High Court with your new gown?
Lord,
Anyway, we would like you to remain as High Court counsel. Let's see. There is some anomaly in this rules. If a party can engage a senior advocate, so can the High Court and the government. There should not be any objection. We'll examine the rules. Otherwise, it becomes very difficult.
perhaps there was a subsequent notification issued by the High Court in
Let's
the
see.
administrative side, excluding, my lord, the standing counsel.
including government, advocate general, government advocate and others, it doesn't go down to the standing council, but standing council for institutions.
Yes,
Correct. But that proscription also is not very justified to my mind.
yes.
Any party can engage a senior.
Anybody, yes.
So if private persons can, why not institution? Why not government?
True.
That's our view.
True.
I mean, that's my personal view. Let's see how my brother also, Mr. Das led the study council for the High Court. They did not. क्या लिखा है तो? Mr. H.K. Das, senior advocate and standing counsel for the High Court, shall also respond to this petition by the next. Highly appreciated.
3rd of August, 28. Item 16.
And the earlier decision, Mr. Das, that we had given,
Yes,
that went to Supreme Court, was it affirmed?
yes. It has been much of that.
So, weak case, only point here, my lord, the only point that under the land policy act, they have acted. But the only grievance here is that they have given a particular portion in such a place, it's a paddy field. I requested before the learned single judge also did not consider. Learned single judge said,
That's the difficulty is this.
yes.
You can't have a choice of it.
No, that's why beggars doesn't have a choice. I know myself.
No, we
I-
don't refer to you as beggars. You can,
No.
we cannot. You are a voter. You are a citizen.
Yes,
Need to
that's
be
a,
protected. You are under duress. You are not duress, you are under distress. But then question is that you can't have a
Only-
place of your choice.
you're right, Lordship is right. Only a request is being made by my learned friend, because they are the government.
They say that nothing can be
No,
done.
it
This is the
can-
place which we have found.
What?
They could have very well said no.
No, 100%. I agree. They should have said that no portion of land. You just go out. But they have done. I'm really thankful to them. But the only problem here, it's a paddy field within the vicinity of that 5 kilo, no evidence are there. That's the only problem, my lord. That's the only problem. Only I request, my lord, my learned friend, that if they can find some other portion, my lord, if it is possible. Otherwise, my lord, I will not utter a single word. Number two, my lord, if that way handing and taking of
So,
possession has to be there.
Mr. Das, you do not understand. People who have to buy their plots,
Yes.
they also go beyond 50 kilometers of their original place of residence. I mean, this is stretching the benevolence of the state a bit more than
My
it
lord,
is
I will not,
possible.
my lord, I will
Can
not.
we, now tell us one thing, Mr. Das, can we pass an order or can we issue a mandamus to the state to give you something nearby, Ulubari or Bajar?
No. Your lordship can't. And I will not also utter a single word. Here something where your lordship will do it. I will never request your lordship to do something which is not also permissible.
This is stoking the hornet's nest. Mr. Das, sometimes later he will come and say that now when they were not accepting it, we have given it to somebody else. So better option for you is,
Only
Mr. Das, because you're a very seasoned counsel, you can advise your client that they should not protest this. The government has agreed.
let them do
Let
one.
you take it
Yes.
immediately.
No, we will take it. But handing and taking over formalities has to be done. Secondly,
That they should.
let them do it, my lord.
That they should.
I cannot only pray that till the handing and taking over is not done. At least for a month, I should stay there, my lord, for a month. That prayer that my children were studying, that particular protected by learned single judge, their exam is over.
That land of his has been acquired for which purpose? If it is
For a biotech park, my lord.
No,
Biotech park. No, I don't want. I don't want, my lord.
National importance.
No,
That is a
I don't
project of
want.
national
I didn't
importance.
say also an utter
He is
word.
in the midst of that land.
My
He
lord,
is in the midst of
I
that
am
land.
not saying.
Sometimes you'll have to advise your client. Some difficulty, some hardship will always be there. We can't.
But 3 weeks times, let them given by 3 weeks. 3 weeks time, I think for,
Ask him.
I am,
Maybe, but this must
3
be.
weeks
the work
time,
must
my
be
lord, I will.
You are in the middle of that park which is to come up.
No, I know, my lord, that's We tried to argue, but whatever may be merit of the case, I will not utter a single word. What I am praying that
Just see
3
if
weeks.
if it could be delayed by 2 weeks, not 3. Just check up, come back to us tomorrow, then we say that.
No, and
And he handed over the land.
handing, handover taking over should take place. No, he is not.
How
No,
many families are there?
one family, one family.
No, land is identified. We are ready to give up the land, madam. Land is identified.
But handing and taking, no, handing and taking.
Handing and taking over is, my lord, only 1 hour formality, 1 hour. That can be done. Yes, it will be done, lord. So maybe please to dispose of this, my lord.
He
With the
says,
direction within
he
2
says,
weeks.
no, don't evict him in 2 weeks.
That's the catch, my lord.
No, for 2 weeks, can you do it?
Yes, my lord. Within 2 weeks, we will hand it over, my lord. We will invite him. Let him come. Let him stay, my lord, peacefully. These are all, my lord, ministerial exercises.
We have heard Mr. Digant-in-person, learned senior advocate for the appellant, and Mr. Pujari. Mr. Pujari, learned advocate for the estate. The appellant, a landless person, claimed that he was in continuous and uninterrupted possession of a land in village Numali Jala in Gauhati district, 1882. However, he was directed to be, however, he suffered a threat of displacement when the land over which he had constructed his house was identified as land over which a park would be made. There were series of legal battles between the petitioner and others, between the appellant and others, and the state. But ultimately, the issue was decided that the area in question would form part of Gauhati Biotech Park. The request of the appellant for being allotted an alternative land under the land policy of the state of 2019 was though allowed, but the choice of the land offered to the appellant is not acceptable to them. The plot which has been identified to be given to the appellant under the benevolent land policy of the state is stated to be too remote and about 50 kilometers away from the current home and place of work of the appellant. The land, according to Mr. Das, learned senior advocate, is a low-lying paddy field with no drainage or basic development. There is no human settlement within the 5 kilometer radius of the land in question, rendering it absolutely unfit for residential purposes. There are no schools or healthcare facilities nearby. And the trouble of the petitioner with the eviction would continue even if that land is handed over to the appellant. The impugned judgment clearly reveals that in consideration of the provisions contained in the land policy of 2019, the state proposed for a plot of land to be given to the appellant for his accommodation. The appellant, the learned single judge observed, was entitled to fair consideration, but he would not have the liberty to choose the plot which would be given to him as an alternative accommodation. We have no reasons to interfere with the reasoning of the learned single judge. However, considering the difficulties of the appellant, we only direct that the land in question ought to be handed over to the appellant, which has already been identified within a period of 2 weeks, positively. And during this period, the appellant may not be able to.
I'm deeply obliged.
With the aforementioned observation, the appeal stands disposed.
I'm deeply obliged.
14 years.
I told my learned friend, I am going to try, but I know myself where I stand. And very lucky that we got an order. And my learned friend is kind enough, the alternative plot has been given to us.
Mr. Porpazari was not very, I mean, he was not strongly opposing your prayer
Yes,
today.
yes.
I don't know why.
No, he tried. He tried. He tried.
He said that
He tried all.
12 years is enough.
Yes.
You have
12 years.
Yes.
So
I'm
deeply obliged.
deeply obliged. Sir.
Item 18.
May it please your lordship. May it please your lordship. My lord, by way of this writ petition, I am challenging the railway board circular by way of which the railways are imposing busy season charge upon the consignors and the customers upon the railway, my lord. And currently, my lord, 15% charge has been levied on any kind of a booking being made.
Mr. Gupta, you appear for the railways.
Yes, ma'am.
Now, under which policy do you impose this? It's all over India.
It's all over.
Challenged anywhere.
No,
Now,
ma'am.
but then busy season was what? You must specify. They will make it busy season in Dasara, in Diwali, in Holi. When? When do you do it?
My lord, it is.
And is it not required to be passed by a parliament? Can you do it by an executive 5A, even though you are railways? That's the question which he has posed.
Yes.
And you need to respond. In the meantime, we are not staying
My lord.
anything, but then we give you only 4 weeks, you respond.
My lord.
And you also tell us whether this has been questioned, this pan-India affair.
Yes, my lord.
So whether it has been questioned in any high court, any other high court, whether the matter has traveled to Supreme Court.
And
Correct?
yes,
So 4 weeks,
No.
a composite affidavit.
my lord.
Is the businessmen are right. Now it has to be regulated. You just can't decide of your own free will that this is the busy season, so we'll raise it by 7% free tickets.
My lord. What is policy?
Public sector undertakings, they have a right to generate income, but it can't be unregulated, no?
Yes.
Take down. The petitioner who runs a proprietorship firm under the name and style of Messrs. Kundan Mal Chaudhary has questioned the legality of the, within quotes likhna, busy season surcharge imposed by the respondent railways on transportation freight. The core grievance of the petitioner is that the surcharge has been repeatedly imposed, modified, withdrawn, and reintroduced through executive circulars without following the mandatory statutory procedure prescribed under the Railways Act 1989. It has been pointed out on behalf of the petitioner that the busy season surcharge was first introduced in the year 2006 as part of the pricing policy of the railways. The railways imposed the surcharge at varying rates through a series of circulars. First off, initially the surcharge ranged between 4 to 7%, but by around 2015, the freight was increased to 15% through a master circular. This surcharge was supplied during specified busy periods of the year, but it only increased the freight cost for traders, including petitioner, for traders alike, including the petitioner. Stop. Later in 2019, acknowledging the burden on stakeholders and declining freight traffic, the respondent railways withdrew the surcharge for most of the commodities. In an effort to rationalize the freight charges. However, later, it was again reintroduced in the year 2022. But this time without any legislative backing or any parliamentary scrutiny. The increase in the freight was further expanded to other commodities. And the policy underwent changes in the year 2023 and 24, whereby the duration during which the surcharge could be levied was also increased. The concern of the traders, including the petitioner, is that such imposition of financial levy seriously affects their rights and liabilities. And therefore, those must comply with the statutory safeguards. The Land Council for the petitioner has also drawn the attention of this court to the provisions contained in sections 198 and 199 of the Railways Act, requiring any rule or regulation having the force of law to be laid before both houses of parliament. The clear contention on behalf of the petitioner is that such busy season surcharge has never been put to such mandatory legislative process. Semicolon, rather, it has been enforced purely through executive instructions, which, according to the petitioner, is impermissible. So the railway 198 and 199 then it becomes void, Mr. Gupta.
No,
You'll have to refund. Because that issue hasn't been raised anymore.
page 24.
Because if the requirement is placing before the parliament, it has not been done, you can't exact even 1 rupee more.
It has been done as per the dynamic
Anyway,
pricing
you
policy
Anyway,
in the year 2015. That has not been put to
dynamic
challenge.
price policy is something else. We are talking about something else.
On the
We're
basis
talking
of-
about something else. Respond without.
No,
Don't give a casual response. If you know it's all right, if you don't, then take instructions, file your affidavit.
Well,
Mr. H. Gupta, learned CGC, to respond to this petition by the next date. Re-notify 6 weeks.
I'm grateful, my lord. Much appreciated.
24 June, 24/6.
Parliament, it has to be laid before the parliament. It has not been done, then we will not be able to sustain it, my lord.
Thousands and crores, my lord, thousands of crores. A busy season has already been.
Wait, but then has it been questioned? It must have been questioned elsewhere.
My lord, I personally conducted my research all over the high courts and Supreme Court. I was unable to find a single judgment in respect to any charge, not just busy season charge, in respect to any charge. I failed to do so in respect to 190.
Bad for you, no? Bad for you. That it is
Yes, my lord.
the approval of everything. I mean, post facto also it could be approved. Anyway, we'll see.
Much of.
Item 19,
My lord, in this item, my senior had appeared and gave a assurance that something will be filed, but till now, my lord, no response has been received.
Where is Mr. Goswami?
My lord, he's coming today, my lord. He's ready to Gauhati today. That apart, my lord, some similar petitions are filed regarding, my lord, some same issue, my lord, but
Just inform Mr. Goswami that on the next date we would like his response.
my lord,
Today he has not come and has not even given you instructions.
my lord.
Here. Ms. Ghosh, we'll wait for it.
Yes, sir.
He had given some kind of assurance. We remember that. Like, yeah, prayer for adjournment has been made on account of unavailability of Mr. P. N. Goswami, learned additional advocate. Learned P. N. Goswami, and P. N. Goswami, learned senior advocate and additional advocate general assam. Re-notify. After 2 weeks, we are putting it. 2 weeks or 3 weeks?
3 weeks, my lord.
3 weeks. Take information, tell us what can be done.
Oh, like,
Deeply.
22/5. Item 20,
Advocate General has said that he will do it.
My lord, as per the last order, state was supposed to clarify.
The Advocate General has said that he will look into the matter. Only 20% of the work is. I had the occasion to visit a place nearby. There's a crematorium nearby.
My lord,
On the opposite side of the. That is different, man. No,
In
lots.
fact, I should have gone and seen that.
Hardly 7 days work is there, my lord. Lots will post it in the third week of May. It will be done, my lord.
As prayed for on behalf of the state. This matter is now for consideration. Make a last week.
obliged.
25/5. Process passed. Item 21,
The judgment logic will find a page 239.
No, he was granted good for 2017-18.
17,
No difficulties.
No.
But was it communicated to him?
Yes, sir. But communication, lordship has para 50 and 51 of the judgment. There is no difficulty with the communication, my lord. In fact, the honorable court has held that it was communicated, para 50 and 51. 50 starts at page 362. It is stated that the respondent authority does a sparrow pay web portal kindly married, my lord. Para 15, it said that it is duly communicated.
Now, tell me one thing.
Lord.
We are not concerned with all this correction and portal and all that.
Para
Did he get sufficient time to challenge that before the reviewing authority?
Yes, my lord. Para
If the great good is not adverse, but then the current position of law is that if it is adverse in particular circumstances, when very good is the benchmark for promotion, then it has to be communicated. To be fair to the officer, everything has to be communicated.
Everything has to be. There is no difficulty with communication. Kindly come to para 51. Kindly say, therefore, the conclusion is by the single judge. Therefore, in my considered view, ACR was communicated disclosed to the petitioner. There is no difficulty with that. It is noted that the practice of providing copies of ACR manually has been discontinued from 2019. Record reveals that the online disclosure in the Sparrow portal of ACR of the petitioner for the year 2017-18 was done on.
It was done in 2020.
No,
Where did he get an opportunity of challenging it, sending it for review?
Well, it was on time because on 6/10/2020, it was.
There is some statement in the memo of appeal that it was. He got time for getting it reviewed so that it could not have run against him for his promotion to the IAS.
Well, in fact, para 51. That is why I have said it was in the. Well, para 50. In fact, if lordship kindly comes to para 65 of the judgment, the problem here, the learned single judge has found, according to the learned single judge, the ACR he has interfered because we failed to follow one office memorandum. That is the ground.
He is not taking into consideration.
There are 43 is very much relevant.
When there is no malafide established, then how could the single judge say that this grading is bad?
My lordship, kindly see paragraph 43, my lordship, the reporting officer, my lordship, in column 8 of the respective file, my lordship, paragraph 43 may be said, my lord. Records of report reveals that in part 2, it is specified that all the targets for the above schemes have been completed time to time, and in part 3, the respond number 7, that is the reporting officer, my lordship, has in fact commented on part 2 as filed by the petitioner, as I agree with the self-assessment filed by the officer. But I filed a self-assessment, my lordship. He said he agreed, my lordship. The reporting officer in his remark in column 3 remarked that the petitioner is fit for field as well as secretariat posting. In column 4, in respect of capacity to promote team spirit and work as member of the team, the reporting officer views are that the petitioner can maintain cordial relationships with superior and subordinate. In column 4, the reporting officer.
Those things.
Yes, ma'am. I'm going to the main point.
7, the reporting officer reported
The petitioner.
that the petitioner is fit for induction into IAS.
Yes, my lordship. In column 9, in the respective assessment of the nature of work time turned out, special responsibilities, extenuating and in aggravating circumstances, the reporting officer reported that the petitioner is willing to take responsibility even in extenuating and aggravating situation and performs the duty without complaining. Though the reporting officer in his report clearly mentioned that the petitioner is fit for induction to IAS, but in his report in column 10, in respect of character and value system, in tendering frank and honest advice,
trustworthiness and behavioral pattern, the reporting officer remarks that the petitioner is not very reliable. But in column 8, in respect of integrity, the reporting officer remarked that nothing adverse was heard. The remarks of the reporting officer in column 2A to 6 and 10 are in contradiction to the remarks recorded in column B, such as just 3, 4, 7, and 9. Reporting officer has not given any cogent reason for the remarks reported in column 10. Thereafter, my lordship, the Honorable Singh has opined that, my lordship, the reporting officer could have taken the views of the commissionerate of the concerned department, and as a petitioner was working in Morigao Jala Parishad, my lordship, so he was working under the Jala Parishad. So their views were also not taken. So due to that contradiction, my lordship, the judgment has been passed, my lordship. And the order says to reconsider, my lordship. In the operative portion, my lordship, it is very much clear that respondent authorities are directed to reconsider the case of the petitioner by taking into consideration the applicable rules and office management. Rules of 1990 which say Yes. that instances have to be given. Yes, my lord. Where is that? Shows, Mr. Nath, it is your turn. I mean, we have unnecessarily
That's
asked.
true, that's true, that's true. Well, Logic may kindly,
Where are the rules of 1990? We normally would not go differently from the assessment made by the officer regarding a junior
well,
officer.
in
So far
fact,
as the reliability is concerned, everything he says it's good.
in
but
fact.
Therefore, this average was, this good was deliberate.
Well, in fact, clarification has been sought from the reporting officer at page 139. Logic will find his clarification. Here, why he has graded the officer as good, that clarification has been sought by the appellate authority while considering the appeal. It is on record at page 139. He said,
Para 47 is also very
no,
much
let me please, Lord, he will please. Let me please.
For 139.
Yes, Lord, page 139. This is the part of the order of the appellate authority's order. But views of the reporting officer, whereas the views of the reporting officer were obtained and are as follows. I would like to make few specific comments regarding para 8, 9, 17, and 18 of the appeal by Prohibitions under faculty. Para 8, the reporting the officer has complained that I have remarked that he is fit for both field as well as secretariat posting and has capacity to promote team spirit and work as a member of the team and maintain cordial relations with their superiors and subordinates. I have also remarked that he is fit for induction into the IAS and willing to take responsibility even in estimating and or aggravating situation and perform his duty without complaining. But in column 10, regarding his character in general and value systems with respect to tendering frank and honest advice to superiors, trustworthiness in fulfilling the assurance and performance giving by him and the officer's behavioral pattern is dealing on matters having self-interest. I remark him as not very reliable. I would like to elaborate here that there was instances during his tenure as CEO Jila Parishad Morigao, where the officer concerned had not followed the instruction given by the PNRD department, but had followed the decision of the Morigao Jila Parishad, and in spite of being told that the decision of the Jila Parishad was not in conformity with the government direction, I have therefore marked him as not very reliable. Regarding integrity, I have not given him any negative report. I have not only remarked that nothing adverse was heard, and this is that it is factual statement made by me. I have graded him good based on his performance as CEO Jila Parishad in 2017-18. I have judged him good based on his performance for the year 2017-18 without taking into consideration the benchmarks laid down for nomination to IS. The grading is based entirely on his performance. But there was instances when the officer had not followed the direction of the PNRD department and had worked according to the decision of the Jila Parishad. Few decisions of Jila Parishad were not in conformity with the directions of the PNRD department. The officer was told about these instances over phone, but it is a fact that no written instruction was given to him. Regarding taking views of Jila Parishad, the on integrity, character, and trustworthiness of the officer, there is no standing instruction for the commissioner of PNRD to take the view of Jila Parishad while reporting on the officer. And in this case, The adverse remark on the officer is because of the fact that the officer followed decision of the Jila Parishad, which is not in conformity with the instruction of the PNRD department. With the above comments and keeping in view the performance of the officer on the flagship program of PNRD, I am not inclined to change the overall grading as good in his ACR, whereas the reporting authority has also viewed that with reference to the above, the assessment of in ACR of Sri so-and-so, ACR, the then CEO Jila Parishad Morigao for the period from 1/4/2017 to 31/3/2018 is correct according to my views. Then kindly see the next page, page 140. The Panchayat and Rural Development Department implements mainly two flagship programs with so-and-so and so-and-so. The performance of Morigao district in financial year 2017 and 18 and under PMGY completion of house against target was decimal 19% approx, which is far below average. In Amendraga, the work completion in Morigao district was only 25.46, far below the state average.
That is not going to make any dent. Where is the procedural safeguard? There are some rules of 1990 or something.
Yes.
What does it say?
The office memorandum, which the at paragraph 65 of the judgment.
2007.
Yeah,
Is that of
that is at page 86. But this provides that since there is no specific provision laid down in the Assam Services Confidential Rules 1990 for recording, reviewing, and accepting authorities in respect of Chief Executive Officer, Jila Parishad, the Government of Assam, after careful consideration of all aspects, have decided to lay down the following procedures for reporting, reviewing, and accepting authorities for annual confidential report in respect of the CEOs of Jila Parishad, provided A. This is their harping. The reporting authority shall obtain special report for the period reported upon from the concerned Commissioner of Division and also from the President Jila Parishad before writing the report. So the learned single judge in para 65, para 65 is the conclusion, para 55 is the finding recorded.
Mr. Nath, we were almost inclined to interfere, but now look at this. You can't disregard the rules. The reporting authority has to obtain a special report from the
Well, here is a special case. Kindly see the
No, we are absolutely fine. There is, see, Mr. Nath, let us frankly, let you know that we don't see any malafide here.
it is
Because it's very objective assessment of the officer, no doubts.
true.
Because otherwise you'd have said bad, integrity bad, I have heard bad thing. He says nothing adverse. But then when he talks about unreliability, when he says that he is fit to be promoted as an IAS officer, unreliability on the basis of his functioning, his style of functioning, where the government circulars were given a go by, and what the Jila Parishad Chief Executive was asking, he did it. Now, therefore, this could be ascertained only from the district commissioner. And you have the rules. It says that provided they is consulted, then only the report would become valid.
Report from the Jila Parishad President.
No.
He has
Yes, the period upon from the concerned commissioner of division and also from the president of Jila Parishad.
Yes, so the president of the Jila Parishad, he is in connivance with with the instruction of the.
We have understood he may be in connivance, and therefore he got his instructions carried through by the officer. He's that way.
Kindly see.
We have seen that. Now you tell us. It says that both. Have you taken the information from, or you have sought the approval or report from the commissioner of the division?
division.
I think that is the ground on which the single judge has decided the matter.
Yes, my lord. That is the ground on which the
So
matter is.
the single judge says that it is not malified, number one. It was communicated, number
Yes.
two. Nothing wrong. But then the procedural safeguard was not followed.
My lord,
How do we question that and set aside that judgment?
logical, see what prejudice has been caused to him by not doing this.
It is because unreliability, a comment of unreliability.
Malad, he has followed the instruction of the president. He has the president of the Zilla Parishad, and he has not followed the instruction of the government. Being a government servant, Malad, being the chief executive officer, he has followed the instruction of the president. And now the report
You
has
have
to be
not
taken
taken
from
any action for that period. In no departmental proceeding, nothing.
Malad,
Now can you take this?
Malad,
When procedure is prescribed that you have to do in these stages.
Lord, may I kindly see the rule says that a report has to be taken from the president of the Zilla Parishad, and Malad, the president of the kindly see, Malad, the president of the Zilla Parishad is to give a report, and he has followed this. That
They are not getting persuaded. Of course, we normally would not interfere with the assessment of the officer. But now another rule which is prevailing, another provision of law which is, or another practice of precedent and another law which is developed is prevailing with us. That we don't find any perversity in the order passed by the 11th Assembly.
in fact, Malad, see,
Consider him and say that he is a litigant kind of a fellow. We will not consider him for that.
Malad, the president of the Zilla Parishad, Malad, that is the reason for recording the remark as good by the officer, that he has not followed the government instruction. He has followed the instruction of the Zilla Parishad, the president's instruction. Now the report has to be shown. Report has to be taken from the president of the Zilla Parishad. So what, Malad, ultimately what the report he will give. So therefore, the explanation he has given, the affidavit of the respondent number 7 is also there on record at page 260, page 260 and 261 of the memo, Malad. Ultimately, the petitioner has pleaded that one office memorandum, kind of the office mandatory nature of the office memorandum, or the purpose for which it is there. Now the president of the Zilla Parishad has inspected, he has followed that, not followed the government instruction. That is the reason for recording the adverse remark, the remark of good.
Judgment is not perverse. It's not. Though, of course, he has entered very deep into
Malad,
it.
in the same,
The moment we don't find any malifieds, we don't interfere with the assessment.
Malad, in the same manner, in the same manner, the ACRs have been written. For the 1718, he joined as the chief executive officer in the year 2016. This is the SCR for 17 and 18.
Get into IAS only by this judgment. You have to take a call. You have to decide.
Malad,
Why do we tinker with this judgment, which goes strictly on facts? The court was cautious enough not to say that this was malified, this was bad, this was not communicated. But it only says that the safeguard which is there in your own rules has not been followed. That's all.
But therefore, the issue before Lordship is,
I don't think. Mr. Nath, we must tell you, we were inclined to allow this.
issue before Lordship is, that whether that particular office memorandum which Lordship has said, the single bench has said, that has to be followed. Without that,
Why have you framed it?
No.
Have you withdrawn it?
This is a peculiar fact situation, because the report has to be taken from the Zilla Parishad, and the Zilla Parishad's instruction is contrary to the government instruction. And that is the reason for recording the ACR remark. And that aspect has been considered by the appellate authority. The reporting officer has also verified that.
Let us see the rules of rule 14. Forget about rule 14. Assam Service Confidential Rules of 1990.
Lordship.
Where is that?
Well, the service manual, Lordship will find, Lord. Well, P54, page number 354.
Back after 5.
You come back after 5.
Lot-
Yes, Mr. Raf, you were at the rules.
Lordship will find the rule at page 354.
Space.
Page 354 in the book. Well, the rule 10 is the communication of adverse remark, 11 is representation against adverse remark at page 361. And 12 is consideration of representation against adverse remark. But rule 12 is relevant. The authority receiving the representation against adverse critical remark shall, if it considers necessary in consultation with the reporting authority, the reviewing authority or the accepting authority, consider the representation made under rule 11 by an employee and pass order so far as possible within 3 months, so and so and so. So the requirement is consultation with the reporting authority here. That reporting authority's reply as per rule, Lordship will find at page 222 in the appeal memo. Page 222, Mala. This is the part of our additional affidavit. On 18th of December,
Yes, one second.
Lot.
Report on special report share. Division. Where is the order dated 28/12/2021?
Well, that's page 140,
Page
140.
140.
Yes,
That is what you were reading.
yes, I read. It is under rule 12(1).
No, but paragraph 66. Paragraph 66 of the judgment, it
Ma'am.
says what? Reconsider the remarks about 17 and 18. That's all.
True, my lord.
You can reconsider.
But
But there is no direction for him to be considered for IAS because that notification is gone.
para 65 of the judgment,
We have followed that.
lordship.
No,
But lordship,
para 65 is para 65. Para 66 talks about the secutor action. Now, we were worried about this, that how is the single judge directed him to be considered for IAS? वो तो नहीं कर रहा।
no.
That is not saying.
Well, in fact, lordship has said, the last single judge has said that the office memorandum which was not followed, that was a violation.
So therefore, the only thing which was not followed was the report of the then commissioner. That's all.
President.
So,
I mean,
why do you want this to be tinkered with now in the appellate stage? Of course, I mean, because rules have been framed, this is the assessment. The officer may think him to be eligible for being promoted to the IAS, but his assessment is that he is only good.
Good.
And he cannot be rated above good.
Lordship.
That cannot be questioned. The only way in which it could be questioned is that there is some procedure laid down which is specially made for CEOs.
Well,
It
only,
is not a general guideline.
well,
It has specially been made for CEO because CEOs are not covered under the rules of 1990.
well,
Correct.
they are under
So when
the,
you make that rule and it is very specific that both opinion has to be taken of the DC as also of the president of the Jila Parishad, you have not taken that opinion, so you reconsider.
well, therefore, well,
So perhaps you are not following, therefore you are questioning this. Now, we are trying to tell you is this. Now, had the court decided, single judge decided that please consider it very good. Consider his candidature for being promoted to IAS retrospectively, we would have interfered.
that is not, that has not been done. That is not the direction. And
Then it is not perverse. The judgment is not perverse.
lo-
Let us not unnecessarily upturn a single judge's order.
well, the issue,
There may be a different view. We are, personally speaking, and I think my brother also is with me, we have a different view in this. But then only because we have a different view in appeal, we are not going to upturn the judgment.
the issue which we are hesitating before the lordship, that whether the office memorandum non-adherence to that itself is fatal in this, because
Why
the,
not?
well, the office memorandum, the region, the consultation with the reporting officer and the rule 12.1 lordship has seen, and he has clarified why it was not done. And
Where is the clarification why it was not done?
page 222. It was on 18th of December 2021.
Page 222.
Yes, Mullah. Under rule 12.1, consultation was done by the appellate authority while considering the appeal.
Just
Mal.
yeah, what is this one? This is the reply given by.
Yes.
Reply on the appellate authority asking him.
Yes, Mullah.
So,
Under rule 12.1, the appellate authority said that you give your reply. So he replied that this is the reason why he has graded him.
where?
Yes, Mullah. The para to the appeal memo of the respondent, he replied to
Which paragraph are you reading? Para 8, para 9, para 17, para 18, which one?
logic. Para 9, he said, I have graded him good based on his performance as Chief Executive CEO Jila Parishad in 17-18. I have judged him good based on his performance for the year 2017-18 without taking into consideration the benchmark laid down for nomination to IS. The grading is based entirely on his performance. There were instances when the officer had not followed the direction of the department and had worked according to the decision of the Jila Parishad. The decision of Jila Parishad was not in conformity with the direction of the department. The officer was told about this over phone, but it is a fact that no written instruction was given. Regarding taking views of Jila Parishad on the integrity, character, and trustworthiness of the officer, there is no standing instruction for the Commissioner PNRD to take the view of the Jila Parishad while reporting.
That's absolutely incorrect.
And
what is para 18 then?
Because
there is no answer. Which reason? Any doctrine of necessity? Where is it? That it was impossible to take his opinion. Correct. You would have agreed with your submission.
The reason is that he has to take the report from the authority against. He found that he acted against the instruction of the law. So therefore, he said that
that's a logic which is neither here nor there.
But
question is that Jila Parishad, he went with the Jila Parishad as the chief executive officer. So naturally, his experience, his opinion would be in the favor of the officer concerned. Now, for a balanced report and for a report to be acceptable, he had to obtain report from the district commissioner also, the then district commissioner, divisional commissioner. That he has not done, and therefore the court says that please take his report of the time and decide. Then we are good kahenge, we will have no objection. But we are repeating the same thing. I thought that the single judge said that you consider it for IS. That notification.
That is not the direction. That is not.
The appeal is dismissed.
Highly obliged. Watch it.
Item 24.
Please, Your Lordship, similar matters, Lordship has fixed on 13th.
Of May.
13th of my Lordship. May I pray that this be also paid with those? I will give a copy of the other Lordship.
You have the number?
Yes, Lordship, I have the copy of the last number. It will be 6262 of 25.
Give it.
And this Lordship.
Yes, Mr. Thabit.
Yes, Lordship, it is there. Okay.
No, we have said in view of similar issues pending consideration by the Supreme Court.
Yeah.
Supreme Court matter has been decided.
Supreme Court Lordship, one matter is on 13th itself. And no, I have got a copy. It is on 13th itself. And another matter is on 20th.
Yeah, let this writ petition be listed along with WPC number 6262 of 2023 and other analogous cases on 13/5/2026.
Item 25.
Yes.
Lord, here we are agreed only by that part of the order, my lord, by which there is a direction to pay, my lord, salary for the period of stay, my lord. My lord, initially, my lord, at page 59, my lord, there was an order of transfer passed, my lord, against, my lord, page 59, my lord, will take it, my lord.
Page 59.
59. My lord,
Yeah.
you note, my lord, that in the remarks column, my lord, this transfer order was on revocation of suspension. My lord, this employee was initially, my lord, posted as assistant superintendent of post, my lord, headquarter in Kachar. My lord, during his tenure, there was, my lord, certain allegations against him, and therefore a departmental proceeding was contemplated by the authorities, my lord, which is at page 62. My lord, what is important to be noted is that, my lord, this transfer was on revocation of suspension. Because, my lord, on the same date, my lord, there was an order of suspension passed. And since, my lord, DP was contemplated, my lord, the department decided to, my lord, transfer this employee, my lord, from Kachar to Dharan. Now, my lord, challenging this order, the respondent, my lord, filed the OA before the Central Administrative Tribunal. And the tribunal, my lord, by order dated, my lord, at page 169, order dated 16/10, my lord, at page 169. Tribunal, my lord, state the transfer order as well as the release order. Now, my lord, during the pendency of this,
Just a minute.
my lord,
So this transfer order was stayed.
this transfer order was stayed, my lord.
Ah.
Now, my lord, during the pendency of the that set proceedings, my lord, at page 237, the respondent, my lord, prayed for a choice posting, my lord, page 237. This is the representation to the Chief Postmaster General. Here, my
During the
lord,
pendency of this stay.
yes, my lord, the representation states, my lord, that Tejpur is almost 530 kilometers away. Continuous road journey of 2 days passing through hilly roads, and there is no direct rail connectivity. Therefore, my lord, he prayed that he should be given choice posting. He gave 4 suggestions, my lord. The authorities considered it, my lord, at page 238. And my lord posted him from Darang to Silchar. My lord will see the remarks against vacant post and on own request. Now, my lord, consequent to this order, at page 239, the OA was disposed of as infractuous.
Because he had joined.
He has joined his choice posting, not the, my lord, initial posting, although there was a stay.
Then what happened?
Then, my lord, at the same time, my lord, he filed another OA. My lord, praying that during the period of the stay, my lord, he should be paid the salary. No, we rejected that prayer by saying, my lord, since he did not join the,
There was a stay. How could he have joined?
my lord, but the
How
reason,
could he have joined?
but we could not also allow him to join, my lord, because it was, the earlier transfer order was on revocation of suspension and DP was already started. Disciplinary proceeding has already started at the same position, my lord, he could not have been posted. And my lord, at page 197, initially, my lord, he's page 197, my lord, will take.
No, but when he was transferred to his choice posting,
No, lord.
he joined. Thereafter, you have no difficulty. But in the meanwhile, there was stay on the order of transfer. So how do you equate it with no order, no work, no pay? Now, if his transfer order has been stayed, he remains at his place of posting and he works. Unless you say that he did not work, he did not attend off.
My lord, the employee was very well aware, my lord, at page 197.
Asked you a simple
My
question.
lord.
Answer that, otherwise take us here and there.
No, why we could not have allowed him to join even after the stay? The reason for it is at page 197. He did,
You don't allow him to go where?
no, after the stay, my lord,
The first time he was transferred from some place to Darang.
Darang, my lord,
You did not allow him to join there.
my lord.
Why?
Because of the reason, my lord, that earlier transfer order was on revocation of suspension. And since a disciplinary proceeding was going on at the same place of posting, my lord, he could not have been allowed to join. There was the order, my lord, page 197.
Where has it been noticed by the cat?
That page 197, my lord, is the order.
Page?
197. The respondent represented.
No sympathies with the respondent.
My lord.
No sympathies. He is facing departmental proceeding. He is making choices for his transfer. All right. But if the tribunal stays the order of transfer, that means that he is working there. If you don't allow him to work,
There was a reason for not allowing.
what could be the reason?
Page 197, my
You
lord.
should have taken the leave from the tribunal. What do you think?
No, that order was not challenged, my lord, that page 197 order. That was not placed before the tribunal or challenged by the respondent. My lord, will see page 197, that is the representation dated 5/10/2020, challenging the initial transfer order. And it says, my lord, the posting is revocation of suspension and his retention and signature is not agreed to. Now, my lord, should the authorities be directed to pay salary where he has intentionally not worked, my lord? He has never questioned, my lord, during the pendency of the stay, or never desired or shown willingness or challenged or filed any IA or, my lord, before the tribunal requesting him to join at Darang.
Joe, but whatever you are required to do, you are putting the blame on him. In fact, if the tribunal would have gone deeper, in fact, money should be recovered from you. Where did you get that stay order vacated? Which effort? Where did you come to the High
Stay
Court?
order and merged with the final order, my lord. It has become infractuous. That stay order, the stay order was infractuous, my lord. There is no illegality in the earlier transfer order passed by the authority. That was not adjudicated by the tribunal. And the employee, my lord, knowing very well that he should have joined at Darang, my lord, and he could not have been allowed to stay at Kachar. He willfully sat over it, my lord. Now, can the authorities be directed to pay salary for the period where he willfully chose not to work? And admittedly, my lord, it is a case of no work, no pay. That is our humble submission, my lord. And transfer order was.
Just a minute.
No.
Respondent was granted leave and was paid salary up to December 2020.
No.
Was he paid salary up to December 2020?
For that period, yes, it was paid from Daran division, my lord. For that, he applied leave. Thereafter, he did not.
There was a decision of the competent authority. That's why it was paid. You come to page 253, paragraph it is quoted by the. Paragraph 11, read paragraph 11. Of the judgment.
Yes.
Read it.
Honorable Central Administrative Tribunal Gauhati, by its interim order dated 16/10/20.
Paragraph 11.
Yes. It is further noted that the applicant was not allowed to join his duty admittedly from 16/10/2020, though there was a clear direction by the competent authority, which was communicated by the Assistant Director, Staff Office of the Chief Postmaster General Assam by communication dated 29/12/20 to the Senior Superintendent of Post Offices Darang Division, which is as follows: pay and allowances and leave case of Sri Tapas Kumar Chakraborty designated as ASP PG Darang Division, honorable cast by this interim order dated 16/10/2020 has stayed the operation of the transfer order dated 29/9/20. In view of the same, I am directed to intimate that the company authority has ordered for drawal of pay and allowances of Sri Tapas Kumar Chakraborty against the post of ASP Darang Division till vacation of the stay order. It is also requested to decide the leave case of Sri Tapas Chakraborty early under intimation to this office. But thereafter, he did not join Manga. He did not join Darang.
अभी तो आपने बहस किया है कि it was not possible and under such circumstances we did not allow him. You've said you did not allow him to join. Where is that order?
They are not allowed me to join in spite of stay order granted by this honorable court.
Where is that order whereby you have intimated him that please don't join? Remain without work. Hey, no. We have heard Mr. H. Gupta at CGC for the petitioner slash Union of India, for the petitioner slash Union of India and others, and Mr. S. Chowdhury for the sole respondent. The challenge in this writ petition is to the order of the CAT, order of the Central Administrative Tribunal, herein after referred to the CAT. Dated so-and-so, passed in OA number so-and-so. Directing the petitioners to pay the salary of the petitioner during which period his transfer order had remained ineffective because of the stay granted by the tribal. The respondent serves in the department, serves under the Department of Posts, where he had joined sometimes in the year 1997. And after his promotion was posted in Kachar division in the year 2016. In the year 2020, against allegations of misconduct, he was suspended, and charge sheet also, and charges were framed against him for departmental inquiry. However, later, his suspension was revoked on September 2029, September 29, 2020. And after the revocation of suspension, he was transferred to Darang division so that proper disciplinary proceeding was carried out at Kachar, where his presence would have complicated the matters because of his seniority in the service. Immediately after the transfer order was passed, a release order also was issued on October 1, 2020, relieving the respondent from Kachar. It appears from the records that the respondent applied for medical leave from October 5, 2020, but it was denied, and he was specifically instructed to join Darang. However, the respondent chose to prefer an OA number 222 of 2020 before the tribunal, challenging the transfer to Darang on grounds of his son's class 12 examination round the corner, his incomplete station tenure, and also on the ground of his wife also remaining posted at Kachar under the same department. Next, the tribunal granted an interim stay of the transfer and release orders on October 16, 2020. So, though an effort was made by the petitioner through MA number 26 of 2021 to get this stay on the order of transfer vacated, but the stay order remained pending for years. It further appears that in the meantime, on the application by the respondent for grant of leave, which was allowed, the respondent was paid his salary up to December 2020 by the Darang division. However, from January 2021 onwards, the petitioners claim that the respondent never joined his duty nor applied for leave. Precisely for this reason, the department, applying the principle of no work, no pay, refused to pay the salary of the respondent. The respondent filed a contempt petition, contempt petition number 10 of 2021, for violation of the stay order, as in the meantime another person had been posted in his place. and later a separate OA number 14 of 2023 to have the no pay letter issued to the set aside and for payment of arrears from January 2021. Treating the period as on duty with 12% interest. The case of the department is that despite all efforts made for getting the stay order vacated, nothing moved forward. Except for a direction from this court to the tribunal to dispose of the MA seeking vacation of the transfer order, seeking stay of the transfer order within a specified period. The tribunal dismissed the MA, thereby keeping the stay order intact. During the pendency of the petition, during the pendency of the application before the tribunal, the respondent had requested for a posting at a nearby place, which was granted, and he was posted at Silchar against a vacant position. But that transfer order also was subject to the final outcome of the proceedings pending before the tribunal. Despite the request of the respondent having been accepted for a transfer to a neighboring place, to a neighboring area, he was not allowed to join. The duty. In the meantime, because of the respondent's voluntary acceptance of the transfer to Silchar, the OA number 14 of 2023 pending before the tribunal had become infractuous.
Now it is OA number 222.
OA number 222
of 2020.
sorry. OA number 222 had become infractuous. However, the tribunal, however, decided OA number 14 of 2023 and directed for payment of salary to the respondent, as he was not allowed to join his duty, and his absence from the work was not because of the action of the respondent. Mr. Gupta, learned CGC submits that there was a reason why he was not allowed to work at Dharan, because there also, the disciplinary proceedings.
No, it's Silchar.
Sorry, at Silchar. At Silchar, because the disciplinary proceedings would have been adversely impacted. There is nothing on record to indicate that any such official order was issued by the department, which otherwise would have been challenged. In that case, the respondent ought not to have been given his choice posting at Silchar on his request. Thus, the tribunal was absolutely justified in holding that the salary of the respondent for this period when he was not made to work could not be stopped, as it was not out of the choice of the respondent. Considering this aspect of the matter, we do not find any reason to interfere with the order passed by the tribunal. The writ petitions and so on. Deeply. How many matters left?
Item 26.
Yes.
Malas, I'll take your lordship to the last order, Malas.
Yes.
Well, what has happened, one order was passed, which was interfered by the Singles Act. By that interference, the entire order has been negated. Now, this person is not supposed to get any punishment out of that order. My lords may kindly look at the order. It's page 101. Para 10, my lords. So far as the penalty is concerned,
Yes.
so far as the penalty is concerned, Rule 67 lays down the penalties which can be imposed in a disciplinary proceeding. Withholding of increment of pay with or without cumulative effect is a separate penalty which is under Rule 67B, and reduction to a lower scale of time of pay for a period without cumulative effect is a separate penalty under 67E. It appears that by the interim orders, two penalties have been imposed upon the petitioner. The appellant authority, while interfering with the original order of dated so has modified the aspect cumulative effect of its withholding of increment is concerned. The penalty is of the year 2013 as on today. The same has spent its force. However, the aspect concerning reduction of a lower stage in this time scale by one stage of 1 year would have a cascading effect. Under the facts and circumstances, this court is of the opinion that the penalty imposed by restricted only to withholding of increment of the period in question without cumulative effect, and the first part of the penalty, reduction of the lower stage in time scale of pay by one stage of 1 year, stands interested.
Let's see the rules.
Balance.
67, my lord.
Yes, sir.
Lordship.
The primary reason for the single judge to have reduced it
Yes.
was that two penalties have been merged into one. Which power the disciplinary authority has? Section 67. If you have a copy of the
Yes,
rules
I do.
before you. It says that without prejudice to any other provision contained in these rules, any one or more of the following penalties could be given. And this is 67B and 67B.
But we have involved 67F, my lord, which contains both.
Major penalty 67F.
Hi. The rules are not.
67F is same as provided the reduction to lower stage and time scale with further direction as to whether or not the officer will earn increments of pay postponing and whether on the expiry of the fee. Then this becomes nothing. Then it says that it's with the single judge's order and modification of the sentence, it becomes nothing.
Lordship, the evidence on record does not lead to the irrefutable presumption that any of the charges
Then
framed against the delinquent.
Your being held guilty also should have been interfered with. No?
Lordship, the entire punishment has to go because it is a case of no evidence. Lordship will kindly see the charge.
You have some years to go in service, no? Or
Yes.
retire.
No, long years to go.
We will restore it to the appellate order.
Lordship, it's a case of no evidence, Lordship. Lordship
In
will.
that case, you cannot plead now. Because in this appeal, the single judge only interfered with the sentence.
Yes.
You should have argued that.
I did so. Lordship will kindly see
Where
that.
is your appeal saying, you could have also filed an appeal that the entire sentence was not removed, it was only interfered, only penalty was interfered. That's a separate cause of action for you. You could also have appealed that no punishment is required. I mean, I should have been exonerated. No punishment.
Lordship,
You should not have been held guilty.
yes.
Have you filed any appeal against the judgment? Can you now say this? I mean, I'm asking you a question. Please
Lordship.
enlighten me.
Lordship, the entire record is before your Lordship.
Please enlighten us because it is not we have not been called upon to say that. We have been called upon to question the correctness of the decision of the learned single judge in interfering with the penalty, which had already been interfered with by the appellate authority. Now, the grounds taken by the learned single judge does not appear to be correct because the major penalty does not talk of any merger. And even otherwise, even if it were not major penalty, if it were minor penalty, two penalties could have been given.
Yeah.
It would not have become a major penalty because it was merged. So this is it. I think I've made myself very clear to you. Instead of repeating
Yes.
my ground before you,
Lordship, the punishment is under 67F. And the learned single judge has rightly interfered with the penalty imposed. Because it is a case of no evidence.
you get the reason given by.
Yes.
Can that be justified by reading section 67?
Lordship will see the entire judgment.
And Mr. You are Mr.
I'm Mr. Bhomik.
Mr. Bhomik, you have not questioned that judgment.
I have.
You have.
No.
So we have been called upon to decide. We have a limited window. Of course, in appeal we can see everything. But
Yes, that is the
but why
point
do we
I'm
do
trying
that?
to make. In appeal, Lordship can see everything.
So in appeal,
Yes.
we are governed by another law, PC Chaturvedi. Why?
Yes, DC Chaturvedi.
PC Chaturvedi.
Yes, DC Chaturvedi. My case before the learned single judge was, it is a case of no evidence. None of the charges.
So, Bhomik, we will preclude you from making this argument for the simple reason that you have not questioned the order, the judgment. You should have. It's not something unknown.
Is there any findings that this is a case of no evidence by the?
Yes. The Lordship will kindly see.
Then he doesn't agree with that. He does not conclude. He says that's a sporadic statement there in the judgment. He doesn't conclude. He says that only penalty is to be revisited and that he does on a ground which according to our estimation is not correct. And you have not questioned the correctness of the judgment in holding you guilty. Please don't charge us for being extra technical, but this is the only way in which these appeals could be decided.
As my Lord Chaudhary has pointed out, whether the learned single judge has given any finding on the punishment
No, no,
imposed.
findings, there is a, therefore we said,
What is the
no.
conclusion?
See, you can't just pick one part of the observation of my brother and then come to a conclusion. This is a sporadic, I mean, this is a casual observation of the learned single judge who does not conclude that there is no evidence, therefore no sentence. He should not be held guilty. Does he say so? No, he doesn't. We can tell you the paragraph I just saw.
Lordship will read paragraph 9 onwards.
Just so, but he doesn't conclude.
Yes, paragraph 9 onwards,
There are many observations.
page 100.
Concerned. You should have questioned it.
Lordship will see, may I read, Lordship? A perusal of the inquiry proceeding would
No, we are
also.
not relegating you to the position of the disciplinary authority's decision. We'll say that the appellate authorities.
Lordship, my case before your Lordship is, since the order passed by the disciplinary authority is based on no evidence, your Lordship sitting in Article 226 can very well interpret. That is the law.
Which law?
Yeah. Yeah, Lordship, yes. Morning I have submitted a list of books. Lordship 2009, 2 SCC.
Name the case.
Yeah, Roop Singh Negi.
Roop Singh Negi is not on that issue. Roop Singh Negi is.
No, I am quoting a particular paragraph.
That's correct. Lawrence Secretary also said it, but where is the conclusion that there was no evidence, so no punishment could have been inflicted upon you? What is the finding is that
Yes,
because
Lordship,
of
that is-
these are the evidence, the appellate authority has rightly reduced.
Lordship,
Is the-
this is why I am reading from para 9 onwards.
9, that is the word.
If your Lordship permits me, I'd like to read the paragraph. A perusal of the inquiry proceeding would also show that the customer in question, whose mobile number had been deferred, there was no apparent mismatch of the specimen signature. And it is only in the context of such specimen signature wherein the involvement of the petitioner would come, as he was the assistant manager. It is also on record that on the particular date, the petitioner was alone, handling all the activities of the branch. And therefore, the action taken by the petitioner has been termed to be bona fide. The charges which have been discussed above are trivial in nature. As noted above, charge number 3 and 4 cannot be attributed to the petitioner, as the allegation of misappropriation is admittedly not against the petitioner.
Of Roop Singh Negi.
Yes.
Now you come to the last part of paragraph 9 of the judgment approved. And read this, I mean, the second but last line from the bottom. You start from there. The court has already noted. Internal page 7 of the judgment.
Yes, this court has already noted the defense of the petitioner that he was not the
Custodian to the surrendered
the
ATM card.
surrendered ATM card. So far as charge number 1 and 2 are concerned, not verifying the mobile number in the form of a customer who had applied for mobile banking service, the said charge, even on the face value, is trivial in nature, for which imposition of the penalty in question
Appears to be
is
disproportionate.
disproportionate and harsh.
Therefore, he concludes that there is an offense. Of course, it is venial in nature. It can be condoned, but instead of condoning it, he thinks that it can be the sentence has been reduced.
Lordship, in 226, your Lordship hands are very wide. If your Lordship wants, Lordship can definitely give justice to the respondent.
But the difficulty is paragraph 10. That does not appeal to us. And that reasoning has been questioned by Mr. Sahavala. If it were only till paragraph 9, I think we would have gone with you. But paragraph 10 has to be interpreted.
So Lordship is,
That is the law.
Lordship, if your Lordship considers the entire gamut of the case, right from the time of execution of the charge till conclusion of the disciplinary.
Modified sentence, what is their punishment?
There is no punishment. The petitioner does not deserve any punishment, Lord.
No,
The respondent.
that is your alternative argument. You
Yes.
have not questioned the judgment. Now, with this modification in the penalty, what punishment do you get then?
I have already suffered the punishment.
How?
My
You face
increment-
departmental proceeding, therefore.
No, my increment has been withheld for 1 year. I have already suffered the punishment.
Mr. Sahiwala, let us go by the. See, so much of ink has been spilled on the merits of the case.
But if that is done, then there will be no punishment. We have to.
No, punishment is there, that reduction in increment is already.
I have already suffered.
No, my lord.
It is only for 1 year. The cumulative effect is.
The cumulative, we do not want the
Mr.
cumulative effect.
Mr. Bombing would have been careful. He would have filed an
Yeah,
appeal.
he ought to have filed one appeal.
If you had filed, an appeal, he would have allowed.
Yes.
So why not this?
My lord, in that case, my lord, in that case, my lord, if that is allowed, well, what will happen? The single judge is going to sit on the orders and pass orders. Only thing is that interference. Otherwise, it should be remanded back and reheard. That can be one aspect of the matter.
Yes,
But
the
as far-
matter may be remanded back to the.
Not to the appellate authority,
Mr.
Can be heard.
Point, please hold on for a minute. Please hold on.
to the appellate authority. My lord. And secondly, my lord, if this is allowed, or this is stated to be.
This is allowed, heavens are not going to.
No, I follow, but only 1 year salary, my lord, that will, we need to return it then. If my learned friend says that it is a.
Body of judgment, the judge was almost inclined to quash the entire thing. He has not done it for the reason of the law that he should have done it, he should have demanded it back for that reason. But then if he has made certain alterations in the sentence, I mean, the punishment, why do we interfere? Really, paragraph 10 is, the logic is incorrect.
But my lord, when this answer
Paragraph
is,
10 logic is incorrect. He could have said
yes,
that this sentence appears to be harsher than what he deserves.
that can be done, my lord. If that is,
We will modify it.
but not to the effect that it results nowhere. Not to the effect.
1 year he has lost.
That, if that is observed, it is available.
1 year he loses.
1 year of increment I have already lost.
That, if that is
Without-
observed, that is observed is all.
Without cumulative.
We clarify.
Ah.
Take it.
Yes, profit increment for 1. The last year already suffered.
Thank you.
The employer / State Bank of India / appellant has questioned the judgment dated so and so passed by a learned single judge of this court in WPC number 1844 of 2015, whereby the punishment imposed upon the respondent has been interfered with and has been reduced to only reduction in the pay to a lower stage in the time scale of pay by 1 stage for 1 year without any cascading effect,
Without any cumulative.
without any cumulative effect, with no adverse effect on his future service benefits. The interference has been questioned on the ground that the learned single judge wrongly construed the provision contained in section 67 of क्या है rules का नाम?
State Bank of India Officers Service Regulations 1992.
Section 67 of so and so, regulation 67 of so and so, which provides for minor and major penalties and specifies that a delinquent could be punished under any one or more of the following, under any one or more of the penalties prescribed for any act of misconduct or for any other good or sufficient reason to be recorded in writing. The learned single judge interfered with the punishment on the ground that the net effect of the punishment imposed by the appellate authority would have had the effect of merging of two independent minor penalties. A disciplinary action was initiated against the respondent while he was serving as an assistant manager at the Titapur branch in Jorhat, Assam. Certain lapses were found which was relatable to the irregularities in the duties performed by the respondent. 4 specific charges were leveled against him. And in the departmental inquiry, 2 of the charges stood true. However, the disciplinary authority disagreed and concluded that all the 4 charges were established. Consequently, the appointing authority imposed a major penalty under Rule 67F of the SBI Officers Service Regulation, namely of reduction to a lower stage in the time scale of pay by 1 stage for 1 year, with no increments during that period, and the reduction having a postponing effect on future increments. Next paragraph. This was challenged by the respondent before the appellate authority, which in its wisdom modified the penalty by removing the postponing effect on future increments. But rest of the penalty was upheld. Next, a review petition preferred by the respondent was rejected. The respondent thereafter preferred a writ petition before this court, in which the learned single judge concluded that the charges against the respondent were of trivial nature, for which the imposition of the penalty in question by the appellate authority was highly disproportionate and harsh. As such, the already reduced penalty was further modified to the extent that it was directed. It was to the extent that it was restricted only to withholding of increments for the period in question, without any cumulative effect.
That the appellate authority had already done.
Without any cumulative effect, with no adverse effect on the respondent with respect to his future service benefits. Mr. Saiwala, learned advocate for the appellant bank, submitted that if at all the learned single judge was of the view that the respondent ought not to have been punished, the only option for him was to remand the case to the disciplinary authority to decide the matter from the stage of the vulnerability which was noticed by the learned single judge. That is, at the level of imposition of penalty. Under normal circumstances, the penalty ought not to have been interfered with. More so when the appellate authority had already diluted the rigor of the penalty which was originally imposed upon the appellant by the disciplinary authority or the respondent by the disciplinary authority. He has further submitted that the logic employed by the learned single judge, that Rule 67 lays down the penalties which could be imposed, that withholding of increment of pay with or without cumulative effect is a separate penalty under 67B of the regulation, and reduction to a lower stage in time scale of pay for a period without cumulative effect is again a separate penalty under regulation 67E of the regulations of 1990. It was thus erroneously presumed by the learned single judge, Mr. Sahewala contends, that the two penalties imposed upon the respondent were merged into one, which was not possible, which was not permissible. The observations of the learned single judge, it has been further argued that the penalties of the year 2013, and therefore as on date, the same has spent its force, is also not understandable. It becomes nugatory only with the modification in the sentence by the learned single judge and not otherwise. And not otherwise. We have perused the judgment impugned and the materials on record. And we find that for reducing the sentence, for altering the sentence imposed upon the appellant, the learned single judge was swayed by the fact that the materials and evidence to substantiate the charge against the respondent was such that interference with the punishment, with the quantum of punishment, was required. The first of the charges against the respondent was with respect to registration of mobile number of a customer who had applied for mobile banking service, and that the respondent was instrumental in registering a different number, without checking the telephone number of the customer, without verifying the telephone number of the customer, that customer. In this context, the learned single judge was of the view that the mobile banking service was started only very recently in banks, and the employees had been working at the bleeding edge of the new computer technology. the training was imparted to only few of the personnel of the bank
And not the respondent.
and not the respondent. The respondent, according to the learned single judge, was the assistant manager who was not even entrusted with the task of verification process. So far as the second allegation was concerned, it was associated with the first charge, namely that mobile banking service could be permitted only in home branch and allowing it in the branch where he was posted only smacked of his negligence.
But at that time, there were no extant instructions on that point.
So far as the two other charges against the respondents was concerned, which pertain to defalcation of certain amount of a customer by misuse of a surrendered ATM card, that also was because of some negligence, that also could be attributed only to negligence of the respondent in not getting the surrendered ATM cards destroyed. It was further pointed out, it was further found out by the learned single judge that there were no materials to indicate that the respondent was involved in any fraudulent activity. And that the responsibility of the safe keeping or destruction of the surrendered ATM cards was on the branch manager and not on the respondent. It was only an assistant manager in the bank. The last of the charges, namely of the last of the charges was of not immediately deactivating or destroying the ATM card, was also not attributable to the sole duty of the respondent's employee. On all these grounds, the learned single judge concluded that the offences for which the respondent was charged was so venial that it required a minor punishment of reduction in the stage of reduction to one stage lower in the pay scale with no cumulative effect.
For a period of 1 year.
For a period of 1 year. In view of the aforementioned findings of the learned single judge and further reduction of the penalty thereto, penalty which had been reduced to a large extent by the appellate authority, we are of the view that the same is not required to be interfered with at this stage. It is not required to be interfered with. The respondent has already suffered the reduction in the pay scale for 1 year, which in the facts and circumstances of the case suffices. What is necessary to be noted is that the punishment must suit the offense and the offender as well. The respondent appears to have overworked to have the money to have the money which was diverted to claw it back to the, to claw it back to the respondent. For the aforenoted reasons, we are not inclined to interfere with the judgment of the learned single bench. The appeal stands dismissed with no orders.
But one observation that the punishment that has already been undergone, that will stand, because what was.
Is we ratify that. Finished. We not say any further unnecessarily, like paragraph 10 of this learned single judge's order. This
Because if they come up and say that 1 year.
already served, finished.
Small.
Shall next.
Great.
Item 27.
Yes, Mr. Naik. What do you have to say?
In this matter, yes, Lordship, we have not yet filed any affidavit, Lordship.
Right.
But in between, Lordship, I received one instruction, Lordship, that is dated. Not an instruction. In fact, Lordship, this is a letter written by the executive engineer to the chief engineer, wherein Lordship estimate was submitted, Lordship, for the, the road.
Then we close this.
Lordship,
Efforts to have the road repaired.
yes.
Do that, because we would not have taken notice of this PIL. For the reason that all bad roads do not justify or PIL.
Yeah, Lordship.
But once it has been entertained by a bench,
Yes.
we will close it if we find that you are taking steps for it.
Yes, Lordship. That has already been
Put it
initiated.
on record.
Yes, Lord.
Mr. Naik, let it, but that the response to this commission shall be filed. Shall positively be filed, but we notify after 3 weeks.
Lordship.
We will close it.
Lordship.
25.5. Item 28.
In this case, Lordship, my instructions are awaited. Although the judgment I do not file with infirmity, Lordship, is wrong for the affidavit, Lordship. Because the petitioners are not qualified.
They have accepted the post, no?
They have accepted. Now they are working also.
But the post which was advertised was of assistant loco pilot.
No, the other posts were also.
Anyway, you put in your response.
Yes.
Because they are underprivileged class.
Lordship.
Therefore, we have to be doubly sure that no injustice is caused.
Lordship.
What is your instruction? You are only keeping quiet. You can argue.
No, Lordship, till that I have no instruction received.
Till date you have no instructions. This
No,
is the
no,
case
no,
which
Lordship,
you have.
Lordship, my senior will do this matter.
Who is your senior?
Yes, ma'am.
That is no ground.
Lordship, they have applied for assistant loco pilot. Lordship,
एक दो लाइन भी बोलेंगे तो मैं फिर accept कर लूंगा. But if you just keep quiet on the ground of your senior, then it becomes very difficult for this court to accept. ठीक है, आपने कुछ पढ़ा है, जरूर पढ़ा. ठीक है, at the instance of Mr. R.K.D. Chaudhary and at CGC, the matter is adjourned for filing of response affidavit in this way. We notify on 3rd June. 4 weeks, 3rd June.
3rd June.
apply.
Item 29.
Mr. Puya, I always say that you are very selfish. When the rules are strict, you say that it is very strict. When the rules are liberalized, you say it is liberalized. It depends. You keep on shifting your stand. Now the requirement is not of any honors degree. You are unhappy because you have an honors degree.
I'm not myself petitioners.
You represent the petitioner.
My lord,
We don't find any anomaly.
my lord, what has happened, my lord, in the mathematics, my lordship has decided few months back, my lord. In that, my lord, they have introduced this honor. My lord, Mr. Anjay Khatania says that he will seek for time today.
There is no mention for time. So let him not seek time. You justify your stand, otherwise you dismiss this petition.
My lord, then my lord, may I please to fix with their house day, my lord.
All right, that you be properly attired.
My lord.
So we granted judgment on your account,
My lord.
not on the account of Mr. Katniya. As prayed for by Mr. A.R. Bhuyan, senior advocate. The matter is adjourned to after 3 weeks.
My lord.
There's nothing in this matter. There's nothing.
Even when I will.
With the new attire, you have a bigger responsibility towards the bench.
My lord.
After making some preliminary argument, you can withdraw this.
My lord.
Right? Otherwise, we'll be asking you, you're a senior advocate, you must understand.
My lord.
It is always very dangerous to have that gown.
My lord. I can understand.
You are with bigger responsibility of showing, of guiding the bench also.
My lord.
Not only arguing your case. After 3 weeks.
My lord.
22-5.
Obliged, my lord.
Supplementary list item, sorry.
See, challenge the amendment in the
My
month.
lord.
So therefore, we will require their response. I don't think you have a case. Do you have any case law?
No, my lord, they have response, my lord. They have responded.
They have filed response.
My lord.
What have they said?
No, they have said that probably as a policy decision, my lord, they have bring this.
They have taken a policy
My
decision.
lord. My lord.
The purpose, there must be some rational nexus.
My
They would not getting many honors graduates, and not necessary that only honors graduates can be good teachers. Their experience would have been bad.
My
And you may not,
No.
you may have a higher qualification, but you may not, pass the muster
lord.
because of your lack of, teaching skills. So all these aspects have to be gone into, and this is purely the domain of the state.
Statement.
How do we interfere?
No, even
पापा जी withdraw करिए, senior advocate तो लिखा ही दिया.
my lord, I'll make an attempt on next day.
All right. All right. Yes.
Obliged, my lord.
Item 30, supplement.
Your Lordships, the counsel for the petitioner in this matter is on his legs before the Honorable Supreme Court, so we're requesting for a short passover in the matter.
Passover is not possible. Missing.
Your Lordships may please consider giving a date for Wednesday if possible then.
Whether appearing fine by the state.
Who appears for the state? This is the same matter when Mr. Kalra had been appearing.
Yes, Lordship.
Yes, Your Lordships.
Surrounding states.
Just inform Mr. Katniya.
Matter may take
So,
after some
Bhattacharya.
time, Lordship.
Please let Mr. Katniya know here to file an affidavit. So we'll be taking up this matter on Wednesday. For the
So grateful.
for the unavailability of Mr. Katniya, learned advocate from the education department, the matter is adjourned to Wednesday.
39.
Obliged.
Item 31,
Meet with lord.
Yes, my lord, this is already covered by law.
In view of judgment date.
Yes, WPC 143 of 26. And minor order dated 23rd of April.
Allowed in terms of that.
Absolutely.
Nil note. Yes, any other one?
stop.
What did you decide in that?
And Lordship was pleased to strike down the rule, amendment rules. As well.
Not Mandal and.
Yes.
Where there was a description that only not 6-7 people can.
Yes. So Lordship has held, my lord, that the classification cannot be done on the basis of, my lord, place, precedence. That is the crux, my lord.
Separate petitions are not required to be filed.
Alia, you have filed. Not least.
One is coming up tomorrow, I have.
And we pass the same order in view of that.
My lord. And so, like,